I think this is going to be a really good session to kick things off. I think we want to try and make this as interactive as possible with the audience. So if you have questions or microphones there, you can feel free to weigh in. But this first panel is going to be, I'm surrounded by some really, really smart people, probably much smarter than myself. Andre Iancu, of course, is the partner at Irell & Manella, Senior Advisor, Center for Strategic International Studies, and a former Undersecretary of Commerce for Intellectual Property and Director of the USPTO. J. Gregory Sidak is the founder and chairman of Criterion Economics. Jeffrey Wilder works for the Department of Justice as Economics Director of Enforcement. And myself, I'm the Chief Commercial Officer of our practice at Aon Intellectual Property Solutions. I've been there for about 3 years. Prior to that, I ran all of Phillips' intellectual property business, IBM back in the day, and other. You can see our bios on the website. But this is our panel discussion today. We're really going to talk about U.S. patent law relating to enforcement and licensing of standard essential patents, really honing in on 5G IoT-enabled market, and talk about FRAND licensing commitments under different jurisdictions. So I think it's a very timely topic because 5G is really burgeoning. So I'm going to spend a little bit of time going through some of the basics so that way everyone, we can level set the discussion, and then I'll turn it over to each of the panelists to give some opening remarks. Then we'll get right into Q&A. So what we're talking about here is looking at what we're calling standard essential patents, that a patent that claims an invention that must be used to comply with the technical standards. Technical standards are published. IEEE publishes the spec around standard essential patents, and determining the essentiality, and this is the difference, is determining a true essentiality is very complex because a lot of companies can declare and do declare standard essential patents. So a patent, the contributor really has declared to be essential to that standard, and oftentimes, it is challenged in court as well as outside of court. I also want to distinguish between what I consider litigation technology areas. So and I'll explain more on this later, but really the technology surrounding the different areas around standard essential patents, and we'll get into that. But the 5G evolution began implementation in 2019, right? So, and there's significant technical benefits from 5G over prior generations: higher speeds, greater bandwidth, lower latency, larger coverage areas, and it's not limited to cell phones, right? That's an important point. It supports a plethora of technologies that we'll talk about. A lot of communication service providers have launched the services, over 300 5G smartphone models. That's a lot for 5G. Before the end of this year, we'll have 500 million users worldwide. A lot of those are here in the US, but suffice it to say it's happening worldwide. By 2026, we'll have 3.5 billion subscribers and account for 84% of the mobile subscriptions in the US. And there'll be a lot of economic activity, 13.1 trillion by 2035, accounting for 0.2% of the 2.7% projected annual global growth. Here's the, what I call a patent stack. So now, once again, we have to distinguish between essentiality and the declared, right? So here's a list of all the publicly declared patents in the 5G stack. You see the usual suspects, some of the Chinese companies. Qualcomm is always on the list, ZTE, Samsung, Nokia, and you see the others. My alma mater, InterDigital, is on there. So there's a lot of companies that claim that they have a lot of patents in this area. And there you see how the proliferation of 5G is really going to take place. You see it in the schematic here, starting in 2019 and then building up. And then you see some of the others like SCDMA and some of these other standards weaning down. And then geographically, you're seeing mostly here in the US by 2026, but then you're seeing some of the other jurisdictions as well. So, infringement. So how can we determine infringement of a standard essential patents? The three areas of interest that we're going to talk about today is where the patent reads on a mandatory implementation of the standard, or in the second case, where the patent reads on an optional implementation of the standard, or where it doesn't read on the standard at all. Patent owners are the ones that declare a patent essential, right? And as a result of that, the vast majority of patents declared essential to the standard are not. And there's lots of studies on this, but the ones that I point to, there's a wide range of 10 to 47% of the patents declared in 2G, 3G, 4G, and now 5G are actually essential to practicing this standard. So up to 90% of the patents declared are not, in fact, essential. And that's very important when it comes to litigation, because that comes out in spades, right? I mean, you go to to the courts, and determining essentiality is a very important point. So in this first scenario, where it reads on a mandatory implementation of the standard, the Federal Circuit says, we really, it makes it easy, right? So if you're a guy like me that has done a lot of licensing of standard essential patents and even litigation around it, it makes it easier to prove, because if a patent covers a mandatory implementation of the standard and the accused product admittedly practices the standard, it's easy, right? In scenario 2, where it reads on an optional implementation, what we're talking about here is it may be essential to implementing aspects of 5G relating to IoT, but maybe irrelevant to other aspects of the standard, like vehicle V2X communication. So all you're doing there is the patentee has to show infringement by proving that the patent reads on the same optional implementation of the standard that the accused product encompasses. There have been litigations already in 5G, and I'm sure a lot of you have seen this. I'm only pointing to 2 examples. IP Holdings versus Samsung, which was back in August, involves 3 patents asserted against their smartphones and tablets of Samsung, which were acquired. So the original assignee was FG Innovation, and they sold this as part of a package. So that's what's becoming more preponderant too. In the secondary market, it's becoming very active and proactive in buying and selling patents around standard essential patents, and they're used essentially as sources of that litigation. Another example is in September, Oppo versus Nokia. Oppo is a Chinese-based smartphone company. They signed a multi-year license agreement with Nokia in 2018, which expired, and in May, they acquire a portfolio, right, related to base stations, terminals, networks from ZTE. What's interesting in this case is that they requested that the court set a global FRAND license rate, global FRAND rate to their SEP portfolio. So we'll get into that, what that means. But this is a first instance where you're trying to get a global rate. And the venue there was in China as well as in Europe. So that one is still evolving. So in the case of patents, I'll level set as far as what it looks like in the stack. So you've got all the U.S. patents here. And by the way, the analysis and the analysis we conducted at Aon, we do a lot of risk analysis on looking at from an insurance angle, what is the real risk and how do you quantify it? So that was the reason why we're just really getting heavily into the standard essential patents. But if we look at all U.S. patents are 100%, we looked at the last 20 years of U.S. litigation. So a lot of it from LexMac and sources like that. Standard essential patents are 0.53%. So about half of 1% of all eligible patents wind up declared patent essential. And then if you look in the small bubble, it's hard to tell, but many companies may over-declare patents for a variety of reasons. And so we're looking, it's hard to tell what number is truly essential without actually having it battle tested. But it's a very small amount, suffice it to say. So we're not trying to figure out true essentiality or finding the distinction between these. We're just trying to figure what we're trying to do. Now, if we look at litigation, we look at the analysis focusing on the subsection of patents and the intersection between the standard declared and the ones that are litigated. What's that spot in the middle there? And what we can say there is the litigated patents, a little under 1% of eligible patents end up in litigation, and are only around 1,000, a little over 1,000 patents are both litigated and declared essential to a standard. Very, very small amount. So the cream rises to the top, as they say. So the questions, I want to get in a little bit on the litigation frequency, because I think it's important to look at. Our standard is declare patents more likely to be litigated. In our analysis, 3 times more likely, right? So an active patent had a 0.83% chance to be litigated. Declare patent was considerably higher. Are they more likely to use at least one standard declared patent? Yes, almost 4 times as likely. You see the statistics there over the same 20-year period. Is the proportional frequency changing over time? We didn't see a whole lot of change there or a lot of discernible trend up or down. I'll show you a chart on that. And then as far as, I mentioned these litigation technology areas, this is where it comes into focus, because the ones obviously that will be the most heavily litigated are in telco, fixed communications, mobile security, as well as audiovisual, some of the codecs and stuff that have been litigated. This is the percentage of SDP cases, once again, standard declared patent cases per year. And you can't really see a discernible trend here in the proportion of patent litigations where a standard declared patent is present. The litigation frequency you see by technology area, you see obviously over on the left at telco areas, but some of these others as well. Transportation auto is becoming becoming higher as well, particularly in the more recent years. So the next chart has to do with damage awards. So now we're talking about litigation severity, right? Are damage awards higher for standard declared patent cases? Possibly, but it's hard to determine because the average damage awards are 3.5x higher for cases with a declared patent. I mentioned that, but it's only based on limited observations with damages, and it's probably correlated with other factors as well. Can the observed damage award size be explained by controlling for company size? Probably. The average revenue is much higher for companies, and I'll show you a chart on that. This is really looking at a logarithmic scale. The distribution of damage for standard declared patent cases is noticeably higher than the overall distribution of damages. You can see that over on the right here. That's why the average damages are 3.5x higher for standard declared patent cases. And so the question remains, are they inherently dangerous on their own or in conjunction with other things, right? Or are they symptoms or another phenomenon? Those are some of the questions we'll talk about. And then if I mentioned the revenue, if you look at the revenue of the companies associated with these patents, you see over on the right here, that's really what this is pointing to. So the damage disparity is a function of the relative company size, at least according to the statistics that we looked at. And now we look at case resolutions. So do standard declared patent cases settle at comparable rates, right? So just focusing on the rate, yes. A very slight increase, and I'll show you a stat on that. And do defendants win at comparable rates to other cases? I'd say yes. What is also interesting is that the claimants don't quite win as often, giving up some share to settlements. And that's what this chart shows here, because the part in gray, you can see the likely settlement goes up with a standard declared patent from 80.8% to 82.8%. The claimant win actually decreases for all U.S. cases versus the standard declared patent cases, which is interesting. But the defendant win obviously goes up just a little bit from 10 to 10.4%. So there is a difference whether you have a standard declared patent utilized in a litigation context in a case resolution. Now I'm just going to quickly hit on a couple more points, and then I'll turn it over to the panelists. But several issues that we'll discuss today. One has to do with something called patent holdup. There's also something called patent holdout that we can talk about too. But the patent holdup issue is one where the patent holder is extracting what they call supra-competitive value for an asserted patent based on the fact that the industry's become locked into a standard. Right, so the industry's locked into 5G. Everybody's got 5G devices, and in this case, the patent holder in this theory is extracting value based on the standard and the transaction costs that would be associated with designing around the asserted patent. So they're saying that, or a lot of preponderance are saying that this holds up progress, right? It's causing patent hold up. And to allay these fears, 3GPP, for instance, requests that patentees who declare their patents essential license them on fair, reasonable, and non-discriminatory rates or terms. And the description of what FRAND means is also up to debate and has been challenged numerous times. Jeffrey Wilder, who's on the panel here, had some quotes around the whole issue of antitrust law. And the question here is antitrust the right tool for licensees who are simply dissatisfied with the whole situation? They don't like the rate that's being offered to them by an SEP holder, and so they go to the court and they challenge that patent holder for antitrust reasons. You've seen that. There have been several cases for that. It's been challenged. And what Jeffrey has said is really, which I like, is a new approach, really looking at to continue to recognize that as encouragement to ingenious discoveries, patent rights are too valuable to renounce, and we should fear that not the many are sacrificed to the few, but rather the few will be unnecessarily sacrificed to the many. So interesting quote, and I think spot on. And we'll talk about that. In a real world, FRAND-related case heard in both Europe and the U.S. over recent years, courts have found little evidence, interestingly enough, of concerted anti-competitive behavior by SEP holders. That's the current thinking right now. And their approaches have been fair, reasonable, and non-discriminatory. So maybe antitrust is not the angle to go in, but we can, certainly if you have questions on that, we can address them. Injunctions is another area that's very, very, it's becoming a burgeoning area in the law. But in 2006, the Supreme Court limited the ability of injunctions, right, in eBay versus Merck. Everyone's well aware of that case. In 2013, USPTO and DOJ issued a joint policy statement recommending caution in granting injunctions or exclusion orders based on infringement of FRAND encumbered patents essential to a standard, finding that the remedy of the injunction may be inconsistent with the public interest because the patent pledged was FRAND licensed. That's been evolving. In 2019, the DOJ, USPTO, and NIST issued a new statement which revoked that 2013 statement and revised their position, barring injunctions, saying that the courts should continue to determine remedies for infringement of SEPs subject to FRAND commitments pursuant to the general laws. A balanced, fact-based analysis taking into account a lot of different factors and all available remedies will facilitate and help through this thinking. President Biden most recently has asked the Attorney General and the Secretary of Commerce to review that statement as well. So in the DOJ letter in 2015, it was stated over the past several years, the U.S. patent courts have recognized this principle of injunctions, making it unlikely that a patent holder bound by FRAND commitment, even one that does not address explicitly the availability of injunctive relief, can secure an injunction in an infringement action. And then, of course, in 2020, they reversed the letter saying that concerns over hold up, and there's that word again, as a real world competitive problem have largely dissipated. So there's been a lot of thinking around that, but that's the latest. So I'm going to pause here. I think I've sucked a lot of oxygen out of the room here, so I'm going to turn it over to the panelists to give some opening remarks, and then we can get right into the Q&A dialogue. So Jeff, maybe we'll start with you.
Okay, great. Thanks, Brian. So I'm delighted to be here. Thanks to Brian as the moderator of the panel. Also, thanks to SIP Squared for the invitation. At the outset, let me just say my views do not necessarily reflect those of the Justice Department. That will at times become clear, I suspect. The one thing I will say also is that Brian introduces or has up here a very useful taxonomy distinguishing between SEPs and SDPs. I intend to abuse that in the sense that when I use SEP, I'll oftentimes just mean a patent that's been declared as essential. And if I worked at it, I think that I could get it right, but I just want to outset also make that clear. So it is an exciting time at the division. AAG Cantor arrived just before Thanksgiving, and he hit the ground running, and is engaging on many, many fronts, among them IP. In July, as Brian mentioned earlier, President Biden issued an executive order asking the Attorney General and the Secretary of Commerce to consider revising their position at the intersection of antitrust and IP, but also very specifically considering revising the 2019 SEP statement, or the statement more specifically on remedies for SEPs. In September, I gave a speech on antitrust enforcement and IP, and today in my comments, which will be quite brief, I just want to retread some of that ground. Maybe three themes that I would emphasize from it. The first is our desire at the Antitrust Division to chart a balanced course at the intersection of IP and antitrust. What does that mean? I think there are two elements to that. The first is when we think about royalty rates and compensation for innovators, we need to make sure that they have the right incentives to innovate. That goes without saying. At the same time, all that innovation benefits consumers when it makes its way into products. And so we need to be mindful that there's a trade-off here, right? If the rates are incredibly high, the perhaps short-run incentives to innovate might be high also, but we need implementers also to participate in the process. And so when I say a balanced course, I mean just acknowledging here that it takes two to tango. Right, we really do need both parties to make the standard-setting process work. Second theme would be the theme of good faith negotiation, some overlap with the balanced course there. It's an expectation of good faith negotiation that drives widespread participation in the standard-setting process. When you have that, when people believe people are going to sit down at the table and negotiate in good faith, you're going to have innovators bringing their best technologies to standard setting. You will also have companies with alacrity incorporating standards into the products we use every day, and that's a good outcome. When firms fail in this regard to conduct good faith negotiation, my increasing view is that the real casualties are the small innovators and the small businesses out there that are struggling, not necessarily struggling, but are creating tremendous value in the ecosystem. That includes the Internet of Things, but includes other markets as well. These firms and individuals simply don't have the resources often to engage in the litigation or to defend against an injunction. And the risk is that in an environment like this, where there is this risk of holdup or a risk that you will find an implementer, say, that's engaging in bad, sort of abusive conduct, say, that some of these smaller entities are just going to drop out. That means they're not going to innovate anymore. It also might mean that they're just going to drop out of the markets in which they're trying to operate, and that harms consumers. And the final point I'll make on this principle concept is all these licensing disputes obviously have an opportunity cost, right? The more time we spend in these heated negotiations that span many, many years, the less time we spend actually focusing on innovation and focusing on getting good innovations into products. The final tenet of the speech is a role for antitrust. To my mind, whenever we have, as we have here, collective action among many horizontal competitors with the potential to confer market or even monopoly power, you've opened the door for liability under Section 1 of the Sherman Act. In addition, there's a string of cases over the years. Rambus would be an example, as would Broadcom, that there's also some scope for Section 2 liability. And one of the things that I declare in the speech, or try to make clear, or at least hint at, is that we're no longer taking a categorical approach, suggested by the 2019 letter, that Section 2 doesn't reach breaches of FRAND commitments. I think it does when the conduct harms the competitive process. And I'd emphasize that focus on the competitive process and harm to competition. And because at the Antitrust Division, we don't see ourselves playing the role of a mediator in licensing disputes between tech and telecom behemoths. We're very focused on, can you tell a story, or is there a problem, or is there a harm to competition? The fact that there are other remedies available for some of the conduct that we see in this space, to my mind, doesn't suggest that that there should be no role for antitrust. Harm to competition doesn't just hurt the beneficiary of a contract or a FRAND commitment. It hurts the market and it hurts consumers. And for that reason, there will always be a role for antitrust when there is a harm to competition in this area. All right, so those are my introductory remarks.
Thank you. Gregory, maybe you can.
Sure. Okay. I also want to say that my remarks don't reflect those of the Department of Justice. And just to be a little clearer, my understanding is that we're on the public record here. That it's not Chatham House rules. So if I decline to comment on a topic, it might be because I have to keep up professional confidence. I've written a lot of articles on the topics that we're talking about today, and with the exception of this one, which is a de novo review of the record in FTC v. Qualcomm, they're all free. This one is sold at marginal cost on Amazon. It's not available electronically. And I'll set some of those things out, and if any of you want to take them home, go ahead. I'll try to make myself useful this morning by saying a few things about what economics can bring to the question of valuing standard essential patents and figuring out how the value that is the incremental value that is created by standard essential patents ends up being divided between the patent holder and the implementer. So economists study value. John Hicks, of course, wrote a very famous book on a theory of value. And at an aggregate level, economists look at the interaction between supply conditions and demand conditions. And sort of one of the first lessons of economics is that markets create and process vast amounts of information, vastly more than any central planner could do. And this use of knowledge in society, to borrow a phrase, that is generated by market processes, is really a profound result of competitive markets. And if your name was Friedrich Hayek, you get a Nobel Prize for that. In garden variety patent litigation, where there are already lots of transactions between the patent holder and licensees, there emerges a kind of market-determined price, and courts call that an established royalty. And there's no need to go beyond that and say, well, what's the minimum willingness to accept and the maximum willingness to pay? We have relatively homogeneous transactions that can be observed. The difficulty is when you don't have an established royalty, and typically the first thing that expert witnesses on valuation or damages in patent litigation then turn to is there a comparable license? Well, if there were enough comparable licenses, you would have an established royalty. So it sort of invites the question, how many comparables do you need before you can start drawing inferences that there's a truly market-determined price for this that doesn't require any further investigation? That, of course, the paucity of information about the amount of value that's created and how it ought to be split between licensor and licensee, that's the recurring issue in technologically dynamic markets. It's the recurring characteristic in disputes over SEPs and what a FRAND royalty or RAND royalty means. And obviously it will be a big deal in the Internet of Things, in the licensing of those standard essential technologies, and in the resolution of any disputes when licenses are not readily entered into by parties. That then invites an analysis of the hypothetical negotiation between the licensor and the licensee, which of course is a standard component in garden variety patent litigation if you don't have comparables or an established royalty to look at. That requires defining a bargaining range, which is bounded by the minimum willingness to accept on the part of the licensor and the maximum willingness to pay on the part of the licensee. That's a pretty well-established methodology in the jurisprudence under the Patent Act, and by extension, it's carried over to FRAND licensing and RAND licensing disputes, which, strictly speaking, are matters of contract. Maybe I should just inject here for a moment. There are two contracts here that I'm thinking of. One is the contract that the SEP holder enters into when he goes to the standard setting organization and says, I'm declaring my patent as being essential to this standard, and I will agree to offer to license it on the following terms, which the standard setting organization has specified. So the parties to that are the SEP holder and the standard setting organization, but there's a third-party beneficiary, obviously, a whole class of third-party beneficiaries who are the implementers. The second level of contractual analysis is the negotiation between the SEP holder and the implementer pursuant to the obligations that the SEP holder accepted when his technology was accepted into the standard. And so that gets into questions of good faith negotiation and how long does this process go on before it might be considered to have broken down. Here, I think it's really important to understand that as a matter of American contract law, one standard-setting organization's RAND or FRAND commitment is not identical to another SSO's terms and conditions. And so, as a matter of contract interpretation, you first have to look at the text of what the obligation was that was undertaken by the SEP holder. Now, it gets more and let me say, for example, the Ninth Circuit has repeatedly, erroneously stated as a matter of law that a FRAND obligation is the same as a RAND obligation. False, absolutely false. That's dicta, by the way, in a number of opinions. But as a matter of just first-year contract analysis, that's specious. An IEEE RAND obligation doesn't look the same as an ETSI FRAND obligation. They have different words. And this, in turn, has relevance to what economists can offer in expert testimony in disputes over royalties, because my experience has been that typically economists, and certainly non-economists like accounting experts who opine on FRAND or RAND royalties, are not being advised by the counsel in engaging them that there are subtleties between one standard-setting organization's commitment and another one's. They're treating this like it's some uniform statute, like the UCC or something like that, and that's just not the case. So a good deal of expert economic testimony is worthless, in my view, because it is opining on a stylized institutional structure of licensing that doesn't exist on the specific facts of the dispute. And getting back to Jonathan Barnett's comment earlier this morning, you have to base the resolution of these licensing disputes on the actual facts of the case. They can't be based on some notion, some stylized notion of what the facts would be if they were susceptible to easy manipulation in some academic theory paper. One other point I want to make is sort of the difference between economic testimony and accounting-based testimony in the valuation of SEPs. An economist is not fretful when he sees variation among comparable licenses. Variation in data is a good thing from an economist's perspective because it helps to explain the legitimate reasons that there are differences in different transactions. And so an economist naturally turns to something like a regression model to explain the variation. And yet what we see, and particularly when you go outside the United States, where I think the use of expert economic testimony is not quite so developed as it is here, there's kind of a cherry-picking exercise. Let's throw out all the licenses that don't look comparable because they're not apples-to-apples comparisons. Well, you don't need pure apples-to-apples comparisons if you approach it from a more what I'll call an economic perspective that takes that into account. I should probably pass the mic here. I just want to make one comment before I do, and that is I've written an article called "Is Patent Holdup a Hoax?" And my view is yes, and I think other people later today, maybe Alex Skeletovich, will have some comments on that, and I'm happy to take any flack from the audience that comment now has generated. So with that, I'll let Andre take over.
Well, great. Thanks, everyone. Thanks for the invitation to be here. Good to be with all of you. Well, Greg, you're not going to get any flack from me on that comment, probably unsurprisingly. But Frankly, statements are being made out there and slogans that sound good, such as patent hold up and hold out and all that stuff. But all these things have to be backed up by actual hard evidence that stands up to scrutiny. And it's important to look at the data. I want to make 4 main points. First of all, obviously from a patent policy point of view, it's critically important for the patent system to provide clarity, stability in the laws, balance, and for IP rights, patent rights, meaningful enforceability from a practical point of view. To me, this last point is critically important to keep in mind for policymakers because we can all talk about theories and academic concepts, but we need to look at the facts on the ground. And we need to know that when we issue rights, obviously they have to be good rights, they have to withstand challenge, but they have to be meaningfully enforceable. In other words, not just theoretically enforceable on paper. That an IP owner, after it goes through the process of securing those rights, and after appropriately defending those rights in whatever tribunal, that they can meaningfully enforce them. So policies, when it comes to IP, have to keep that in mind. And this is in part why in 2019, the administration revised the SEP policy, policy statement from 2013. I want to emphasize that the 2019 policy statement was not a rejection of the 2013 statement. It was a restatement of it because we thought it had come to be misapplied. A statement that was made in the 2013 policy position that recommended caution in granting injunctions. Of course you have to have caution when you grant injunctions in a situation of FRAND commitments. The eBay case requires that. Obviously, you have to go through the 4 factors. Obviously, when you do that, you do it with caution. But you don't transform that in any practical per se rule against injunctions in FRAND-encumbered SEP situations. Because if you do, as it actually has happened in the ensuing years after the 2013 statement, you create unintended consequences. The 2013 statement, in fact, had a footnote that said in certain particular circumstances, injunctions are appropriate. That seemed to have been overlooked in the ensuing years. So that was the point of the 2019 statement, and to Jeff's point earlier, it had in mind precisely the concepts that Jeff mentioned. One, balance. Balance between innovators and implementers, patent owners and the users of those patents. Good faith in negotiations was an important point. And as a result, what we said was that standard essential patents are patents too. And all the standard laws for patents, including the eBay case, needs to apply, all of those need to apply equally to standard essential patents, and then courts should have the freedom and flexibility to decide each case on its own merits. Effectively, what the point of the 2019 statement was to take the thumb off the scale, the administration's thumb off the scale, when courts are adjudicating standard essential patents, and let those courts make the decisions for standard essential patents under prevailing law, including eBay, just like they would for other cases. The 2019 statement does provide examples of what to do in situations of FRAND-encumbered SEPs. Take into account good faith behavior. And if, in fact, the implementer, the ones who want to use those patents, do not behave with good faith in FRAND negotiations, well, then perhaps courts should consider injunctions as an appropriate remedy when they decide. When we talk about hold up and hold out, as I've said earlier, I'm not an economist, but it is really important for policymakers to pay attention closely to the actual evidence and the economic studies that point to whether there are hold up out there situations and hold out situations. From a practical point of view, not just a theoretical point of view. So, and let's look at actual facts on the ground. Let's look at actual examples. And I'll give you one example. Obviously, there are many, but I want to clarify. Neither hold up nor hold out is a good thing if it actually happens. And whatever policy any government has should discourage those types of behavior, obviously. Take, for example, the HTC v. Ericsson case, where Ericsson had an established royalty rate of $250. HTC didn't want to pay the $250 rate and didn't suggest something close to that. HTC wanted to pay only 10 cents. And, you know, not afraid of any consequence, not afraid of an injunction or anything else, filed actual affirmative litigation against HTC, trying to force a much, much lower, 96% reduction in that royalty rate. That theory was just recently rejected by the Court of Appeals. Obviously, the case is probably still ongoing with potential further cert petitions to the Supreme Court. But that's just one example. There are various examples, and policymakers need to take a look at it. My conclusion has been that bottom line is the administration, as a general principle, should get out of the way here. If nothing else, administrations come and go. It is not advantageous for a stable patent system to have fluctuations in IP policy of this sort with every new administration. Take that thumb off the scale and let standard prevailing law take hold and let cases be decided as they come before the courts. Finally, let me make a point that Brian alluded to a little bit, and we can come back to it more in the questions, and that is the international aspect of FRAND and SEP litigation. There's a lot of activity nowadays on these issues. So various courts around the world have taken to issuing global royalty rates. And some courts have been issuing anti-suit injunctions so that royalty rates can be decided only in their jurisdiction and nowhere else. Others in response have issued anti-suit injunctions. Those issues have been litigated, continue to be litigated. It is a very interesting new development. But it's something that policymakers here in the United States need to attend to because, to some extent, it is an impingement upon our national sovereignty and the independence of our courts. It is indeed odd that the foreign court can dictate to a U.S. court whether it can hear in its court in the United States claims of infringement of a U.S. patent on U.S. land and try to prevent that type of an activity. And it does have an impact on how worldwide litigation and licensing can take place. But that's a longer discussion, and we'll see if we can get into that more in the Q&A. So with that, I'll turn it back to Brian. Thanks all.
Yeah, thank you for the remarks. I think we can start with one theme that hit across just each of the panelists, and I'd like to throw actually this one back to Greg because he kind of teed up with your book that you have. Is patent holdup a hoax? And you were pretty strong in saying yes. You want to go into a little bit more detail on your thoughts around why that is the case?
There are a number of reasons. I think I'll mention only two and let the others, the other reasons come out throughout the day. One is that if you're using the model of holdup that Oliver Williamson, who won the Nobel Prize, developed, one of the necessary conditions for holdup to occur, and holdup is a more precise concept than just charging a high price. It's charging a price high enough to extract the quasi-rents of the counterparty. And so it's a pretty precise economic concept. But one of the requirements is surprise. It can't be something that's expected, because if the threat of holdup is expected, it gets baked into the cake in terms of the negotiation terms. Right. All right. So, is there anybody who practices patent law in the world today who hasn't heard about holdup? And is there any client of that of any patent firm that hasn't received some client notification, newsletter about patent holdup? No. I actually went through a search of all of the reported references to patent holdup in litigation and identified the law firms involved. And so the question is, well, what law firms are left that have never heard of patent holdup? Virtually none. So it's just kind of silly. And then you can carry that on to the next level. What economic consulting firm that provides litigation support has not contacted, a client to tell them about, this new patent holdup decision that just came out. So that's just ridiculous. Now, I'm sure Alex will probably be able to elaborate more on some of the other nuances of economic theory. The second point I want to make is that the patent holdup thesis, I think, completely crumbles as a matter of common sense. If you think Qualcomm is holding you up and you're Apple, you can buy Qualcomm. You don't have to litigate. You can just buy them. Apple had more cash on hand during its war with Qualcomm than the market value of Qualcomm. And of course, Apple doesn't have to buy 100% of Qualcomm. It only has to buy a controlling interest. It's nonsense. The market for corporate control, as Professor Manny taught us many years ago, is an alternative vehicle for resolving disputes between companies that are publicly traded. We didn't see any such transactions. What inference do we draw? It wasn't a big enough problem to rectify through the market for corporate control. So I would encourage you all to think about that. And I encourage the Justice Department to think about it, because the insight is relevant beyond just standard essential patents. It's true in any Section 2 monopolization case where the bad guy is smaller than the good guy who's supposedly being harmed. And just common sense.
Well, I'll add, from a practical patent litigator point of view, patent owners want to license their patents. Right. What do they get out of this holdup situation? Okay, so, okay, I'm going to hold you up. You're not going to, let's assume Apple succeeds and Qualcomm succeeds and puts Apple out of business. Completely unreasonable to think that, but that would be the logical conclusion. What does Qualcomm get out of this, or the other patent owners? It doesn't make sense. Whereas on the other side, the folks who want to use patents can actually hold out for a long time. If there are no consequences of meaning at the other end, why not just go through every step possible under the law, which will take years? And then if the patent owner survives the multiple challenges in district court, at the patent office, at the Court of Appeals, back down usually in the district court, back up to the Court of Appeals, and finally you come out at the other end, probably 5, 6, 7 years down the line, then all you have to do is pay the royalty rate that you would have probably paid at the beginning anyway. Okay, that there's virtually effectively no cost to that from a practical point of view, and the unintended consequence of the eBay case, you're holding out for 5, 6, 7 years. That's the practical consequence. And as a litigator, I'll tell you, you see that happening all the time. And as a practical matter, you really don't see a quote, hold up situation as it's classically defined. So what I encourage policymakers to do as they assess the issues, look at the practical situation on the ground, put up the facts. If people think that there is a hold up situation, or if people think there's a holdout situation, give real world examples, name them, name the case, and put the values on the table so that we don't just talk in theory, but we talk in actual practical effects.
Okay, a few reactions from me to that. I am in a different place with respect to holdup, so I think that's probably good for the panel and for the purposes of keeping everyone awake during the entirety of the session. Maybe 3 reactions in particular. So the first is Andre made a couple of appeals, and I've seen these over the years, to the lack of empirical support for holdup being a problem. And it's just a theoretical concern. You know, I am reminded of, I used to vacation at the Grand Canyon on the South Rim. There is a fence along the edge to prevent children from falling in. I feel like arguments like that sound a bit like, listen, no one ever falls in, so let's just get rid of the fence. There is I think, a real theoretical problem here, but it can have real world consequences even if we don't observe it. And one of the reasons we might not observe it a lot is we actually have institutions that have arisen over time, for example, RAND commitments, that help mitigate that problem. So that's a thought on that. I'm sure Andre will have a response. I did want to also loop back to 2 of the points that Greg made, which is there needs to be surprise for holdup to be a problem. I also, I think, disagree with that, and so let me put a little flesh on that, and then he can respond and explain why I'm wrong. So to my mind, suppose there's no surprise at all, but I know this is an inherent problem, right? I'm always going to face it in the marketplace. Well, as an implementer, maybe I don't adopt the standard and maybe I strike out on my own instead. If we think the standard creates value for consumers and for society writ large, then that's a problem. I think that's a harm. And so I don't think there needs to be surprise I agree for the holdup to work, there needs to be surprise, but in the end of the day, as an implementer, it changes my economic incentive to adopt a standard. It surely does, if I know it's going to be a problem. And then also I wanted to respond to the notion of Apple buying Qualcomm. I think we can all anticipate that might result in some antitrust scrutiny. There are particular vertical issues there, and I think we can't just abstract away from that there actually is antitrust enforcement Perhaps in a world where I could solve every dispute I have by just merging, I agree that that is a resolution, but I think it would be a rocky road to try to do that in that particular instance. And I realize it wasn't about Apple versus Qualcomm, it was a broader point. But again, if there is a lot of dependency upstream, my expectation is other firms might also be dependent, and so that could actually raise antitrust concerns. I have a couple of additional thoughts on the SEP statement, but I'm going to stop now. Maybe we can loop back to that. I'm in a slightly different place about whether the 2019 statement was just a restatement of 2013, but maybe that's for later. I'm just going to flag it, put a pin in it.
One thing I wanted to say, I liked your statement, Andre, about patent holders want to license their patents. That's a fact, right? I mean, when I was at Philips, when I was at IBM, when I was at InterDigital, when I was at Verizon, you know, there was a licensing program. We wanted to license whether or not it's a standard essential patent or a non-standard essential patent, it's clear. You want to have, and there's a lot of transparency around what that rate's going to be, right? A lot of companies declare, Ericsson among others say, this is my rate, right? So anybody that's implementing 5G, here's what you're going to have to pay. So the question is whether or not these SEP holders are holding up progress, right? So has it resulted in a delay or an effect of implementing the technology? Has it affected the proliferation of 5G devices or 5G-enabled devices in the market? And I think the answer is no, right? I mean, it's actually growing. It's growing exponentially. So holdup becomes an argument that perhaps is difficult to accept based on that.
Brian, could I respond to that
Sure.
point just quickly, and then I'll turn over the floor?
Yep.
Look, I think the question there is what is the counterfactual, right? And we don't know it very well. Like, to say that 5G devices are exploding, it's a very valid observation to make, but would they be exploding faster otherwise? We don't know. So I wouldn't just, I think it's a more complicated empirical question than that.
Right, so an implementer has a decision to make, and Jeffrey, you said an implementer might think twice before getting into offering devices because they're afraid of that landscape, they're afraid of what might happen. But it's no different than if they were offering non-SEP patents that were not in the standard essential patent market. In other words, there's patents around medical devices, right? And they could be in the medical device space. They're still going to have that same concern because there are litigious companies with very, very valid and quality patents that might become problematic for them.
Right, I agree, except for the fact that perhaps the sunk cost there might not be as extreme. So to the extent that someone came and alleged that I infringed, I could then basically build around in a way that I can't if I'm implementing a standard, say.
Okay.
If I may respond to a couple of things. To Jeff's point about the fence at the Grand Canyon, and now we don't really, and Jeff's observation that we don't really observe patent holdup, and maybe that's because of the good fences we put in place. I really don't even know what to do with that, how to respond to it. I mean, if we all agree that we don't observe it, then why do we keep trying to put in new fences, new guardrails to protect even more against it? It reminds me of some typical legal advice. When I ask, if I'm a client and I ask my lawyer, hey, Mr. Lawyer, should I go visit the Grand Canyon? The lawyer says, well, really dangerous at the Grand Canyon. If you go with your child, he might fall in. And I know we put a fence, but the fence could break. And you might as well not even fly there, because if you fly there, you might go to the fence and the fence might break. So don't even leave the house, because if you leave the house, you might get into an accident on the way to the airport, or the plane might fall, or if you get off the plane, you might die on the way to the fence, and if you don't, you get to the fence might fall and the shot might go in, so don't go to the Grand Canyon at all. Well, you can't make policy that way. If we don't observe hold-up, then let's just admit we don't observe hold-up. Because I can tell you, we observe hold-out. I just gave you a concrete example of hold-out. And I have countless other examples, and every patent lawyer on both sides will have examples where the accused infringer will just simply say, I have a million arguments against these patents. Why don't we see it out? We'll play it out for 5, 6, 7 years, and we'll see where it goes. One final point. If all the laws that we have put in place and all the guardrails we have put in place, and we think they work so well, why is it that we see such an incredible concentration of wealth and economic activity in the big implementers here in the United States and around the world? Why is it that, the implementers are getting bigger and bigger, and market power is concentrating so much in just a few companies? If things are working for our antitrust and economic policy surrounding standard development are working so well, why are we still advocating for even more guardrails that would enable the big companies to get bigger? To Jeff's very early point from the beginning, that I agree with, that if we're not careful in the balance that we put in and the good faith that we encourage on both sides, the primary folks who are harmed are the small innovators. They are the main casualty. That's what Jeff said, and I fully agree with that. That's where the disruptive innovation takes place. Disruptive innovation takes place at the margins. It's in the small and medium growing companies that, on balance, for a society of our size, that's where the action is. We need to make sure that our laws are properly balanced, that they are not put out in this process of trying to innovate, raise money to innovate, real difficulties in obtaining IP rights to protect that innovation, and then hurdle after hurdle of trying to meaningfully enforce those rights. If those are not properly put in place and balanced, then these small innovators, the disruptors, are being harmed, and then we as a nation fall behind.
I'd like to follow up Andre's point with a comment about the style of argumentation that's being used here, both legal and economic. The assertion is made that there is some dystopian outcome that will happen in the counterfactual world, and therefore we must act prophylactically. So, as a matter of due process, what does that mean? It means that you have now said everything that is not permitted is forbidden. You must disprove my utopian counterfactual conditional if you want to do something. Now, ordinarily, the burden of proof in antitrust law is on the prosecutor or the plaintiff. But here, the innovator is told, you have to disprove what is essentially a non-falsifiable proposition. I have this utopian view of the counterfactual world. Prove me wrong. Well, how? What data? What data are you going to summon to disprove something that is supposed to happen in the future in the mind of some Berkeley or MIT economist who's the expert witness testifying for the Justice Department? It's assuming the answer because it's a non-falsifiable exercise. And we've just turned principles of allocation and burden of proof on their head. That's what I talk about in my de novo review of FTC v. Qualcomm, because that's exactly what Carl Shapiro's testimony was doing.
Okay.
And I would say it is a style of argumentation that we see in economic policymaking broadly. It's not limited to antitrust or IP.
I think the last thing I want to say on holdup is just that, getting back to your point, Andre, that it has to be based on empirical evidence, right? Not based on theoretically it could be a problem. In this instance, what is the evidence around this specific case that is creating the issue, right? Is there an actual holdup issue in this specific case, right? One of the questions that came up is, and you started mentioning it, Gregory, is on the antitrust. I want to get back to Jeff, when you were talking about the role of antitrust and really as it affects the competitive process, you said. So, Gregory just said the burden is on the plaintiff to try and really prove that out, right? So the question is the antitrust the correct tool for licensees that, if they're dissatisfied because they don't like the rate that's being offered them by a SEP holder, is that the justification to raise an antitrust claim and attract, really attack a broader business model versus the specific question that's at hand, which is, the rate's too expensive?
Yeah, it depends whether you're litigating in the United States or in most of the rest of the world. In the United States, setting aside instances of fraud on the patent office and the like, there is not a Section 2 cause of action for excessive pricing. So American antitrust law is not a remedy for the complaint that I don't want to pay the price that you're asking. Now, obviously, Article 102 in Europe explicitly provides remedies for excessive pricing on a unilateral basis, and similar statutes in other countries would do the same. So it depends a lot then on where these cases get litigated.
But there's been over recent years, there's been no evidence of concerted anti-competitive behavior, either in Europe or the US, in any case that I'm aware of, where it's actually been held up, right?
That's my understanding as well.
Right, so
yeah.
that's, so that, maybe that's where we're at as far as, that there continues to be not enough evidence to prove that out, right? I don't know. Do you guys have any other thoughts on that?
Well, let me just respond and say that I do think in the US it is still the case that a deception case makes good sense as a Section 2 violation under the Sherman Act.
But that's why I said setting Walker process cases to one side.
Got it, okay.
Yeah. So, I wanted to mention a little bit about what you started talking, Jeff, and Andre, you picked up on it as well, on the royalty rate as far as this trade-off you mentioned, Jeff, between the implementers and the patent holders. And the question is how to really manage this trade-off, because you mentioned this one case between HTC and Ericsson, they're at $2.50, they're at 10 cents or whatever. How do you bridge that gap in this sort of litigation context? I mean, that's a huge gap, in what really is the way to think about this?
You could go ahead. I actually don't have a great response to that in a litigation context about me.
Well, even without a litigation context, right? So you're trying to talk about value. I mean, you mentioned the royalty rate determination, that there is this trade-off. But that trade-off is, oftentimes, it's hard to bridge that, right? How do you bridge such a drastically different picture of what the rate should be, right? I mean, on the one hand, Ericsson publishes their rates, and this is what it is. They're being very consistent, hopefully, in offering FRAND terms and saying $2.50, whether or not you're a Chinese company or a U.S. company, whatever, this is the rate. And then HTC coming in and saying, well, too bad, I'm only going to give you 10 cents.
Yeah, I think that's fair to say, that in my experience, there are vastly different views as to what constitutes a RAND rate. I mean, obviously, we've seen courts rely on comparables. As an economist, what I think that the exercise we should be thinking about when we do this is we say, well, let's say that we went back in time before the standard were set. What would that negotiation look like? What are the options that are available? How might the standard have changed? All those, I think, are important questions for, unfortunately, oftentimes a court to be asking, which I think is lamentable, because you'd like to see a lot of these disputes resolved in amicable ways where everyone puts himself in the shoes of the other. And that's the emphasis on good faith negotiation. But I suspect no one has a magic formula that kind of says, well, you divide the two in half and take the square root or something. I don't know that that's out there.
Can I add something? The fact that there is a disparity of 2 orders of magnitude between the offeror and the offeree doesn't mean there's holdup going on.
Right,
It means there's an enormous amount of value that's being created. That is the bargaining range. That is the surplus. So that's a good thing. We should applaud that. The reason that they're fighting over that is that there's been such an enormous pie created. Now, is FRAND a point or is it a range? My view is that it's necessarily a range. It's any point between the minimum willingness to pay and the maximum willingness, minimum willingness to accept and the maximum willingness to pay. What's the likelihood that you end up near the boundary at the bottom or the top? Not very much, because even though every point along that interval is mutually beneficial, we seem to know intuitively, and maybe this is behavioral economics informing us, that if I say, I'll split the gains from trade with you 99-1 as opposed to 80-20 or 60-40 or 50-50, you'll be offended. You'll think, well, wait a minute, that's a piggish thing to do. I'm going to get up and walk away. I'll walk away from a transaction that would actually make me better off by a penny because you want to keep 99 cents. We don't want that to happen. And I think this also plays into the concept of good faith negotiation and also what the meaning of fairness is when you go from a RAND obligation to a FRAND obligation. We want the parties to achieve contract formation as quickly as possible and get on with compensating the owners of the IP and letting the implementers freely use, not freely, but use the technology without concern that they're going to be impeded in some way by legal process from developing their products. I've suggested that the meaning that fairness has that makes FRAND unique and different from RAND is that it is a recognition that the parties need to come in from the margins of that FRAND range to try to make sure that one party doesn't get upset and walk away from the table. I think we intuitively understand that splitting the gains from trade in a way that's relatively equal is more likely to lead to successful contract formation than one party insisting on splitting the gains in a very lopsided way. I'll add my own experience empirically in cases is that when it's possible to do calculations of the division of the actual gains from trade, I have never seen a patent holder getting a majority of the gains from trade, not even close. It's a percentage, probably less than a third at most.
If I may add something, Brian, somewhat different from what's been said so far, because I agree with these points on the actual negotiations. Well, two things. First, the way you described it, Greg, I don't know why it's any different from the negotiations when I go to a car dealer and try to buy a car. We reach an agreement when the price I'm willing to pay is within the range of the price that they're willing to sell at. And frankly, why is the government involved in setting policy here in this area when they're not involved in setting policy in all these other negotiations? But I'll put that to the side because we probably are well beyond that issue. The one thing I wanted to add is one possible solution to Brian's main question is how do you set these rates is why don't the standard setting organizations have this discussion ahead of time in the standard setting agreement and create a range? Now, I understand it's very difficult. And all the participants at the standard setting meetings probably, it would be difficult for them to agree. But maybe the Band-Aid should be pulled then, and it would create a lot of or significant improvement in the certainty down the of implementing the standard down the road. Just a thought, recognizing how difficult it is, it doesn't seem to get much easier after the standard has actually been adopted.
Yeah, no, I agree. And wearing my patent holder hat, so bringing back my experience at Phillips and having negotiated a lot of licenses around standard essential patents, it's hard to vary because you have FRAND obligation, right? So I'll bring back the Ericsson example, right? They're offering $250. Well, that's the rate that they've achieved and signed with other third parties. That's why if they suddenly say, okay, we'll agree to your 10 cents, that goes beyond that because it's no longer a fair, reasonable, and non-discriminatory because you're discriminating them versus others that have already signed up to that royalty rate. So that's why FRAND is such an important issue because it does set a benchmark. When you're having this and you publish the rate, publicly, you're saying this is what it is. It's hard to make substantial deviations because this whole apples to apples comparison becomes into play.
Two quick thoughts on that.
Yeah.
So first of all, with respect to Andre's proposal that you start to move some of the discussions about rates earlier, I think that's a very sensible idea. My recollection is that that was what motivated the VITA Business Review letter in 2007 to the Justice Department. Mm-hmm. And so for those who have not thought about it, there's some discussion there. The other thing I wanted to respond to a little bit is Greg's sort of proposed range for FRAND rates. And one of the concerns I have, and this may not be a concern for Greg because he believes holdup doesn't exist or is a hoax, his words, not mine, is doesn't that maximal willingness to pay include some of the quasi-rents? If you believe holdup is a problem, doesn't it include some of the quasi-rents? And isn't that sort of the fundamental issue we have here, right? If it were about sharing gains from trade, I think that would be benign. I think there is an issue on the view, if this is a view of some, I'm not saying it's necessarily true, that the implementer downstream has created a pie, okay, and now here comes the licensor and it wants a big slice of it, but it's the implementer's pie, right? And that the value add of the IP is actually much smaller than the pie that the implementer is trying to get a share of, right? Sorry, the licensor is trying to get a share of. I'm not taking a position on it, but I think that is kind of the fundamental issue. And maybe I just tee up this question just for you specifically of the maximal willingness to pay. It seems like it exceeds what could be ran if you think holdup is a problem.
Yeah. Well, it came out in testimony in FTC v. Qualcomm from testimony by an Apple witness that Apple was paying $15 or less in royalties on an iPhone. So I'll leave you to draw your own conclusions about whether that was bumping up against the maximum willingness to pay.
Yeah. So the last question, before we open it up to the audience for questions, I wanted to circle back, Jeff, because I know you put a placeholder in.
Oh,
Yeah.
yeah, if I may, the only area where I would, so I agree that the 2019 statement is largely a rehashing of the 2013.
Right.
Where I would disagree is there is a footnote in the 2019 statement, it's footnote 9 for those who don't know, that purports to sort of cabin in the scope of antitrust. And depending on how it could be read, and I don't think that was a restatement. I think that actually on the antitrust front went a little bit further than the 2013 statement. And I think the 2013 statement was also pretty, in the body of the text was pretty clear that a constructive refusal to deal, or an example where, for example, you have a licensee that operates in a jurisdiction where damages cannot be awarded, could be subject to exclusionary relief.
Well, but would you agree, Jeff, that the 2013 statement was misapplied and misinterpreted from a de facto point of view in the ensuing years, where we ended up with a status quo that effectively prevented injunctions in any FRAND encumbered SEP case?
So the question that had invites for me is whether that had to do with a 2013 statement or just eBay in the United States, right? I think eBay does make a natural consequence of eBay is that you are going to have injunctive relief be pretty rare, provided you face a willing licensee.
Okay, so then, but it does sound like we're in agreement that a statement that basically tells the courts, just simply apply eBay. Apply eBay in this case, just like you're applying eBay in all the other cases, and apply the facts of each case, and however you decide, you decide.
I think we largely agree. It's just where I take issue a little bit, that's a little strong, but is that footnote. I thought the footnote was definitely an extension beyond what we said in 2013 and marked a real departure, as I read it at least.
Yeah, what I particularly liked about the 2019 statement was the fact that they recommended, this balanced, fact-based analysis, which takes into account all available remedies, right, depending on the situation. I think that to help facilitate this sort of competitive posturing.
And I completely agree with that for the avoidance of doubt, right? That's what I've been trying to message here in part.
Okay, so wanted to open it up for questions. If not, we've got plenty here we can still go through, but I know you must have questions. Please.
I wanted to follow up on Mr. Wilder's antitrust comments about harm to competition being the standard. And so my question for actually all of the panelists is, would a refusal to license a component, an SEP, within a standard, meet this harm to competition bar, even if the essential technology were otherwise available, for example, through non-assertion?
So let me take a second to process that question, and then I'll give it to the others who have a little more experience in terms of what's maybe, no, you don't have a great answer. So I am reluctant. Let me then not respond to that just because I don't want to implicate potential cases we have or circumscribe what we can and can't do. I apologize.
My view is that the strategy that Qualcomm developed, which I think would fit your fact pattern, was lawful and was upheld by the Ninth Circuit as being completely lawful. A practice of not licensing at the component level, but having a policy of non-assertion doesn't harm competition and shouldn't violate the antitrust laws.
So I have a question for the panel, but I think primarily not to pick on you, but Mr. Wilder, because I suspect I know what the others on the panel think. So if you look on Apple's website right now, you can purchase a Wi-Fi, a 5G-enabled iPad for a certain price and a Wi-Fi only one for $200 less. What does that say, given the numbers we've heard here about $250 being Ericsson's rate or the total of $15 of royalties on an iPhone, about whether or not the implementers are actually paying the full value of the innovation that they're using, particularly in the cellular space?
Look, it's a good question, and I acknowledge I don't know all the specifics of Apple's licensing and its pricing. I will say how a firm chooses the prices can be complicated, right, and to price discriminate. That might be a tool that they use. I don't know. Here's what I would say I'm reluctant to say, is that it's as simple as saying, well, that delta there that is identified on the Apple website is all of the value added by that chip. I think it's a much more complicated question. This gets us back to the emphasis before on a fact-based inquiry, and I think you'd have to really dig deep to figure out what the right answer to that question is.
Yeah, I think, Wi-Fi rate is much different than a 5G rate, right? So, I mean, that's one piece. And the second piece is Apple makes their decisions on launching products, thinking through, looking in a crystal ball and saying, how much do I realistically budget to spend on licensing fees with companies that might have Wi-Fi patents or companies that might have 5G patents, and that gets factored into the overall pricing. Now, whether or not they've completely factored that all in is another question.
you essentially were doing hedonic demand analysis, right? I used to use the example of 2 web pages from the Ford website, the Mustang with the convertible top, the Mustang without the convertible top, and the difference was $5,000. So what's the price of a convertible top? Let me think. So let's continue this technique further. I mean, suppose you had 50 different features of an iPad that were used in different combinations, and you could tease out what the incremental valuation was from actual transactions that consumers had engaged in. That's what hedonic price analysis does. I think it's the most promising area of empirical analysis for valuing patented features of multi-component products, and that would include a lot of products that contain SEPs. So I've done it for memory modules. I've also gone back and done a hedonic analysis of the multiple components of smartphones. Now, one thing about hedonic analysis is you can't back it up to the day before the standard was adopted, or even farther to the day before the SEP holders decided to invest in their technology. It's only possible to do because you have actual transactions to look at, so you can only do that after the products exist. So to the extent that there's that clashes with either Georgia Pacific or academic statements about how we want to do some kind of simulated ex ante analysis, it's a problem. But I guess I've found inner peace with that limitation because I think an ex post empirical replicable process that's based on publicly available data or publicly supplied data from private vendors, it's probably better than engaging in a lot of these counterfactual hypotheticals about what technology was an alternative to the chosen technology at the time the standard was adopted. And that strikes me as ultimately not a very promising path to go down, because it's going to be very, very contentious. Ultimately it'll be a battle of futurists, basically. Here's what the technology would have looked like if we had gone down this different path. And as an economist, I don't find that particularly convincing.
I do worry a little bit. Let me just say, sort of react a bit. Suppose that I sell a car and I sell the car with different paint jobs, and I charge the same amount for all the paint jobs, although one of them clearly includes some particular alloy that I need to put in so it sparkles in a particular way. And when you run the hedonic, it says, well, that alloy isn't worth anything, right, because they're all the same price. Does that mean that the licensor's RAND rate is 0? I think the answer is no.
Right.
So we have to be a little bit cautious, arguably, but I've not thought about this as much as you.
Yeah, well, there are a number of reasons why you wouldn't jump to the conclusion that the rate is 0.
Right.
It's at most what you're learning from the hedonic exercise is what is the incremental value that is created.
Yeah, but I just said it's 0 because we charge the same amount for all of them, for every paint job, just because it's too much work, and I don't want to actually, people really like metallic red, so be it. You can have a metallic red car, and it's on me, the extra $25. All I'm saying is that there's a lot going on, and relying unduly on the hedonic can probably result in mistakes in either direction.
Yeah, well, there are techniques that are used, like a lasso regression analysis, where you first estimate what are the most promising features to include in your multiple regression.
Right.
But
yeah.
that's getting down in the weeds for us today, I think.
Okay, one additional question.
I just wanted to make sure this microphone worked because I saw tech support, so I'm not trying to jump the line. Sort of rising up to the 1,000 feet view, perhaps, I was just wondering how the idea that many of the implementers one day are an innovator in another circumstance. In situation X, they might be an innovator in situation Y. So there's a lot of cross-licensing between the parties, et cetera. How does that play into some of the beliefs you've asserted about hold up, et cetera? And then thinking about the 5G Internet of Things revolution, where we might see it not necessarily in all cases be the 6 regular players that you pop up at the front, where you see Huawei and ZTE and Nokia and all those, where there might be a much more diverse range of players who may be smaller even coming into the fray, much more disaggregated, et cetera. How would that also play in some of the analysis and some of the facts we might need to look at, keeping in that sort of seeking knowledge through truth if we were to channel our inner Deng Xiaoping? So thank you.
Anyone want to take that?
Yeah, I think in smartphones, there was a big change that happened when Apple entered, because Apple didn't have much of a portfolio of patents, and so it clearly was not interested in returns to its patents portfolio to the to a greater extent than it was interested in what it would pay to get access to other parties' portfolios of patents. The other thing that happened too, of course, was that Nokia and Ericsson, their business models changed fundamentally, and they got out of the business of making smartphones. So at an earlier stage, the participants in standard setting adoption might have looked different in the sense of being both implementers and portfolio owners both, but that's changed over time. So I think that I think that the change over time works in the direction of polarizing these debates.
Yeah, so I agree with that. From a practical point of view, I'll tell you what I found is that you're right. Obviously, all these companies also innovate. They some of them, it's the traditional implementer companies also innovate. Many of them have patents. Many of them have a lot of patents. But what happens over time in practice is that the folks on balance either will tend to be more on the implementer side and more on the patent owner side, and therefore they will advocate for policies in one direction or the other, not both. So that's a practical effect, and I think it's got to do with, from an economics point of view, with what Greg just explained. The other thing is that as a general principle in human life, there are always more consumers of innovation and creation than the innovators and creators. That happens in music, in art. There are always many more consumers of music than the makers of music. And that's true in technical innovation. There are many, many more users of technology than those innovating that technology. Policymakers need to attend to that issue and need to pay careful attention, not to be not to be swayed by the overwhelming voices on one side, because that's ultimately the government's role, to make sure that the system is properly balanced, that we protect all interests equally, despite the fact that numerically there may be more people and more dollars on one side versus the other.
Do we have time for one more question? All right, so I know you've been waiting patiently, and then
Thank
we'll...
you. So I was very interested in the discussion about the 2013 letter and
Yeah.
whether perhaps it had a chilling impact in the subsequent years. And I think that what I heard was there is some form of agreement that perhaps it was advising a comparison similar to the eBay factors. But with regard to the International Trade Commission, if you recall, when the USTR representative actually decided to veto the Samsung versus Apple exclusion order, he leaned heavily in his veto letter on the 2013 advisory letter. And as you know, the ITC doesn't apply the eBay factors in its analysis. So doesn't that indicate to us at some level that some, either from a policy perspective or perhaps some district courts as well, took the 2013 letter, and especially the last two paragraphs of the 2013 letter, perhaps a little too far, and read it in a way that would essentially prevent any type of SEP assets from receiving injunctive relief protection, particularly at the ITC, and that's still a hot issue, as you know.
Yeah, so my response would be, in short, no. Let me put some flesh on it so it's a little more satisfying. I think there was, a belief at the Justice Department. I think at that time, I think it persists to this day, which is sort of Andre's point, that eBay makes a lot of sense. And the reliance there on that statement was, to my mind, not a reliance on the text of the statement, but rather looking to the logic of eBay, right? And sort of extending it from the context and extending it to the ITC, to that kind of thinking about irreparable harm and all the factors laid out there. So I don't think it was an absolute prohibition, though, by any means. I think it was designed, I think if you read the language of the 2013 language closely, I do think, and there might be some dispute on this, but I do think it comes across as really fairly reasonable. I take the general point that Andre makes, that it was misinterpreted, and am not really in a great position to divine how everyone interpreted it, nor do I know all the arguments made. I'm familiar with this space, and I know people make arguments in self-interest all the time. And so I have no doubt that people pushed it to the limits and said, look, this is a de facto prohibition. I don't believe that to be how you should read that document.
I can't disagree with much of what Jeff said, except his first word, no. I would change that to yes, and then everything else that he said. Yes, I believe it was misapplied, and the 2019 statement begins with that it created a de facto anti-injunction rule, both at the ITC and in district courts. I'm heartened to hear that there is no disagreement on the basic facts, that there shouldn't be a de facto rule, that we should lean on good faith, and there should be balance. In the end, my view remains that this discussion points to the ultimate conclusion. Let the courts decide on a case-by-case basis. They're in the best position to weigh those facts and to apply the appropriate balance in each particular case.
Okay, on that note, I just wanted to mention the panel 1 CLE password for the remote attendees is STARTAC, STARTAC, STARTAC. So wanted to make that note. Thank you to the panelists. I think it was a great discussion. Thank you.